Welcome back to Classroom Insiders. This is season 2. I am excited to start this season off with some great students. This season, we are going to be talking through notable insider trading cases. And the way it's working is that I'm going to have the students tell me which case they want to discuss, and we'll walk through that case and talk about its relevance or its importance in the full arc of insider trading that we discussed on the last season. So now we're going to have, again, just some notable, interesting cases that I think hopefully everyone will love. So I'm joined here by 2 students, and I'd love for them to introduce themselves. Alex and Alon, tell me a little bit about you and introduce yourselves to the world.
So my name is Alon. I'm a 2L right now, interested in intellectual property law, but find this class very interesting.
I am Alex. I am also a second-year law student here at Washington and Lee University School of Law. I am more interested in business and corporate law, still figuring out exactly what, but this topic has just been super helpful in understanding kind of the scope of business and ethics in law. So it's been great.
Thanks. I am excited to talk to you guys today. I think this is going to be a great discussion. I'm thrilled to hear what you have for me and what insights you have about insider trading in general. But let's start with which case it is you want to talk about, and if there's something we need to know before we dive into this particular case. So whichever of you wants to go first, go ahead and give me a little bit of an overview of what we will be talking about today.
We chose the case United States v. Chow. And the reason why we chose this case is it's the type of sensational, lurid tale that people imagine when insider trading comes up.
Yeah.
There are secret code words, live lobsters, and jars of honey, all factoring into the formation of a chain of tippers and tippees used to benefit from insider trade information. But this case also reveals the flaws within the personal benefit test and perhaps more importantly, fundamental issues with who faces the most punishment in insider trading schemes.
Awesome. That is, I mean, for those of you who did not listen to all of the first season of this podcast, tell me a little bit about what that means when you say the limits of the personal benefit test. What is that? Let's talk a little bit about that before we get into what happened actually in this Chow case.
Sure. So the context of insider trading law, I think, is most important to understand with this case is we have this theory of classical insider trading. And that's what you imagine when somebody is working for a company or has a duty to a company and they obtain insider information that is not public and they choose to trade on that information and benefit off of it. And so this was really kind of solidified under Chiarella, which held that there was no duty to disclose when the person who's traded on the information it does not have a duty to the company, was not the corporation's agent or fiduciary or someone where the sellers had placed their confidence or the shareholders had placed their trust and confidence. So then we had Dirks, which really set the stage for tippy and tipper cases. And this is the law that Chow really relies on in its analysis. And they found that a tippy assumes a fiduciary duty to the shareholders of a corporation not to trade on non-public information only when the insider breached their fiduciary duty by disclosing the information and the tippy knows that there's been a breach. And so Dirks goes on to provide a couple examples of when a breach of duty occurs. And that depends in large part on the purpose of the disclosure. So Dirks was actually like a whistleblower case and was an example of somebody who obtained insider information and then disclosed it in order to prevent people from kind of being taken in by a fraud. But that's frequently not the case in insider trading cases. But yeah, so this Dirks essentially lays out that the test is whether the insider will personally benefit directly or indirectly from disclosure. And this can be through a pecuniary gain, a reputational benefit, or a relationship between the insider and the recipient that's a quid pro quo, or even when an insider makes a gift of confidential information to a trading relative or friend.
Okay. That's super interesting. And like I said, hopefully those of you who listen to this from the first season remembers some of these important cases. Both of the ones that Alex was referring to were penned by Justice Powell, who was an alum of WNL Law School, of WNL. And so we always, I think, have a moment to recognize our important alum, but also realize that he single-handedly rewrote a lot of the laws around insider trading, and particularly with those two cases Alex was talking about, Girella and Dirks. And into that space, it looks like Chow is post Dirks. And so where are we in the timeline of insider trading when we talk about what you guys are going to talk about today, which is the Chow case?
This case actually falls kind of in between. This case was decided by a jury in 2011, an appeal in 2013, but in between that time, a case called Obis was decided. Right. Obis was decided in 2012 in between the trial and the appeal. And what Obis essentially said is the trade of non-public information, material non-public information in breach of a fiduciary duty can be to someone who knows the other will likely trade on the information or disseminate that information to somewhere else. So essentially it's kind of discussing a tipper-tippees chain situation. And this is something that leads to this case as well, because this is also a tipper-tippee chain. So in this case, Winfred Chow was an expert consultant for primary global research between 2006 and 2008. And she was also a contractor in NVIDIA. In these roles, she provided information about semiconductor industry to financial analysts.
And so through her providing this information to financial analysts, she was essentially able to use her job at primary global research as a way to get money in what appeared to be a legal way, but kind of behind the scenes was using insider information. Do you want to talk a little bit about the exact scheme she used?
Yeah. So between 2006 and 2008, she ran this scheme where essentially tippies would leak the quarterly earning reports of these two companies, NVIDIA and Marvel. The information would then be transmitted to hedge fund managers who would compare the earning reports with the whisper, which is the unpublished rumors and published expectations of Wall Street analysts. Pretty simple. If the earnings fell below the expectations, the hedge fund managers would go short and sell their stock positions. If it exceeded Wall Street expectations, they would go long and buy more stocks. The tippers she used were Sun Nok Nguyen, and he was a coworker of hers in NVIDIA, and Stanley Ing, who was a friend of Nguyen who worked at Marvel Technology Group. They transmitted the earnings reports to her. She then reported that to hedge fund managers by the name Samir Bure of Tribeca Capital Management and Noah Freeman of Sonar Capital Management.
So the reason why this case, I think, got so much attention, especially in the news, is because of some of the juicy facts. Chow used code words that were then on recordings that Samir Bure had made. So she called her tippers cooks, money sugar, and confidential information recipes. And in her trial, there were recordings of her telling Bure, cooks don't talk without sugar, so throw some of your sugar to me.
Throw some of your sugar to me.
And this is just an example of kind of how this seemed so unlike your typical, it seems like something out of a movie, essentially. And on top of this, she both gave and received a number of kind of extravagant gifts, iPhones, live lobsters, gift cards, a jar of honey. And there was a lot of talk about this, but she made roughly $208,000 by Primary Global through the fees paid by her customers, which included the people that she was tipping the information to. And so that's pretty much her primary money that she received through this scheme.
Yeah, it is true that when you read the news and all the reports around this case at the time, for some reason, jar of honey made it in nearly every report. I don't know what the value of a jar of honey is, or what let's think it is, but apparently it's significant because that was an important fact. And live lobsters, that's all in there. Okay, so around $200,000 she makes, but okay, go ahead.
This testimony was actually the recordings. That specific one was provided, I believe, right before the jury deliberated. They kind of marinated on that very weird recording and then damning recording, really.
Yeah.
I also think it's notable that this comes at a time where the U.S. Attorney in Manhattan was really cracking down. They brought charges against 54 people, 44 pled guilty. Only 6 took it to trial, and they're all convicted.
In just this thing, you mean, in this for this exact bits of information, all the people linked to actually Chow, or is that what you mean, or just in the
in general, right?
It's like it was a little confusing when we were researching it because Chow's specific case only centers around what I guess 5 people, including herself, like the 2 sources and the 2 people that she was providing tips to, but they then had broader connections to this larger sting at large. And so, yeah, it wasn't like she didn't necessarily have connections with all other 54 people, but these were all operating within similar circles.
No, that's right. And she's part of, I mean, for those who recall, the sort of larger sting and prosecution of the Galleon Group, whose CEO is Raj Ratnam, who actually I think just recently got out of prison because I think he had an 11-year sentence after all this. But she is connected in that sort of broader Galleon Group case that dealt with these expert networks and things like that involving her company of Primary Global Research. I think that's right. Okay, so let's go back to Winfred though, Chow. So what happens? What is the takeaway? What are your thoughts about what the jury says, what the appeal says? Walk me through that.
So yeah, after a 3-week trial, she was convicted of conspiracy to engage in insider trading with 1 substantive count of insider trading. She was sentenced to 4 years in prison in order to forfeit $3.118 million of profits that her tippees made.
Right.
And obviously she appeals the issue.
Just some added context, because we mentioned that there were 4 other individuals involved. So both of her sources, Nguyen and Ang, pled guilty and testified against Zhao, and they both received probation. And both of the tippees who received information from Zhao,
the hedge fund managers.
Yes, the hedge fund managers, Beret and Freeman, received supervised release or probation and were ordered to forfeit about $215,000 and $180,000 respectively. And they were the people who made millions off of Zhao's tips.
Yeah, it was a very inverted sort of sentencing outcome for Chow in particular, especially because she wasn't making millions. She wasn't inherently wealthy at all. And so I think the Chow stands for a lot of things, but I think that was another sort of interesting fact of just how justice played out given this scheme. Sorry, were you going to say something else, Alon?
No.
Okay.
Yeah, so I think we can jump into what she actually appealed on. If you want to start us off.
Yeah.
Yes. The main thrust of her appeal was, in relate to the insider trading, was regarding the benefit that her tippers received. She also appealed the admission of the recordings between her and Beret. But the relevant issue here in the insider trading context is the benefit that her insider tippers gained. So she claims that the trial evidence only showed, it was insufficient because it only showed that Nguyen provided NVIDIA's earning data out of sheer desperation to stop her relentless pestering of him. Now, she says that Ng shared similar data from Marvell because he was lonely and just valued her friendship. The court rejects these arguments. They say that because Nguyen got free meals at a restaurant, the iPhone, the lobsters, the honey, the gift card, that qualifies as pecuniary gain. Now, Ang was a little bit more on the edge where I think the real problem is. The fact that the court says that the fact that Ang did not receive any tips from Zhao's investment club in return for the tips that he provided was irrelevant. Just by joining the investment club, he had the opportunity to access information that could yield a future pecuniary gain. And because of that, he entered into a quid pro quo relationship in Chow. Now, I think this is kind of problematic. First, it kind of changes the language that from Dirk's, where Dirk says the information will result in a future pecuniary gain. This is just a possibility. I also think that it's important to note it's a criminal case, and the burden of proof is reasonable doubt. Where's the burden in showing that a mere possibility could occur? Right?
Yeah, that's a good point. So it's
Um,
broadening the liability standard, or it's broadening I guess, the evidence that would be needed to show a personal benefit. It could just be the possibility of
right.
something could be sufficient evidence of a personal benefit, which is, you're right. I think that's a fair point. It's not what Dirk says.
Right.
And so what is it? Sorry, Alex, did you have something to add?
No, I don't think so. I think this was kind of if you have questions, we're happy to talk about the analysis, but yeah, I don't have anything specific.
Yeah, no, I mean, I guess my question for both of you would be, what do you think about this case? You think this is correctly decided? This is, I think, is the first one. And then do we think this is justice? Do we think this is where the law in the normative sense should land, that should be considered illegal activity, and that this absolutely is the just punishment or penalty under the law for this activity? I think the Zhao case tees this up vis-a-vis certainly co-defendants and other people in the Galleon group scheme, which I know is outside the scope of just this case, but I think that is definitely, that got teed up here, which was she had such a different outcome, I think, than a number of others. But yeah, I just would be curious about what you guys would say about how, if you think this was correctly decided.
I think that Zhao did commit insider trading. I mean, I think the evidence is pretty extensive, but I also think that this case didn't fit as neatly into the personal benefit test as the appeals court tried to make it seem. It was fascinating how short the opinion was. Really only 5 pages of like substantive analysis. And I think that was one of my issues with it, is that it felt like they were just kind of assumed there was a personal benefit,
Right.
especially to Aang. And I think that in large part has to do with the fact that before Zhao's trial, Aang and Nguyen pled guilty. And so it's kind of almost as, oh, in pleading guilty, there must have, like, it must meet the elements. It must meet the elements beyond a reasonable doubt. And I think at her being the middleman and the only one really trying to fight the charges, just ultimately, it really unfortunately did not serve her well. And the fact that she got 4 years, and I mean, we didn't even mention, but she couldn't afford to post bail. And so in the years leading up to her trial, she was kept in a maximum security
Right.
prison before, like, after her trial, she was eventually transferred to a federal facility. But yeah, which is just crazy for someone who didn't even make the millions
Right.
off of the information. She made a couple 100,000, 200,000. Oh, like, not that it's not a lot of money, and not that it shouldn't be punished, but
And I think a lot of it is the fact that she was like crucified by the media.
Mhm.
I mean, if you think about it, she's the middleman, right? They paint her out to be this person that ran a scheme where, if you think about it, the tippers were the one betraying their company with their knowledge. The hedge fund managers were making millions knowing what they were doing. She was the middleman transmitted, but they paint her out to be this architect
yeah,
of
criminal
right.
mastermind.
Right. Yeah, she had a court-appointed lawyer even though, all of those who were in large firms representing a lot of the co-defendants in the Galleon group, no one fared well, regardless of whether you had a court-appointed attorney or not. But because almost, I think, to a person, everyone was found guilty. But still, it's true that she did take a really hard fall. And so where do you think doctrinally, or in terms of the insider trading regulation and laws that we have been talking about, where did we sit post Chow? Do we think Chow moved the needle after Dirks? Where does it fit in your sort of understanding of what, if anything, has changed, or if Chow changed the law at all?
I think the most notable case from before this was Obis, which was again decided while she was waiting for appeal. And there they reversed a summary judgment. Essentially, they were saying there was an issue of fact where it was enough to take it to the jury, right? Just the fact that there could be a personal benefit. Here, this was a conviction, just on a mere possibility. And I don't think that it fits the criminal burden of proof.
Do you think it would meet the civil burden of proof if this was an SEC versus Chow case? Do you think it would be different?
I don't. It doesn't seem like there was really, maybe it wasn't discussed in the appeal, but there doesn't seem to be evidence. I don't think that the mere possibility of something happening is something that could be said to have been proved to a reasonable doubt that something could happen. But what if Ang just learned of insider trading law or decided he doesn't want to trade on any information? There's no gain.
Yeah, no,
And
that's a
so,
fair point.
I mean, I think if we're sticking to the black letter law of these tests outlined, I don't think it fits.
Okay, Alex, what do you think?
I have kind of two parts to my answer. On the one hand, I think the evidence presented on Ang's is very weak, and I don't know that it would meet civil standard. I do think Nguyen's is more
Yeah.
demonstrative of a pecuniary gain, even through, it's like a little weird because it's through the form of gifts, but we understand it's a little bit interesting on like how do we interpret Dirks, because we have seen Dirks used as like an exhaustive list of examples, but I think we have an understanding that's not necessarily what Powell intended. And I think the case of Nguyen is an example that would fall under Dirks, under the way that Powell intended it. Of there is some gain. That gain can be live lobsters in a jar of honey. When there's an exchange, like you're meeting that standard. But I think in the context of insider trading law as a whole, I think this did err towards broadening personal benefit test and kind of just let's squish, like, this feels wrong, let's squish it in because, and just make it fit the mold, because we know that this isn't right, and we don't want to allow this under our laws. And then it's kind of interesting to see so I think she could have been sentenced up to 25 years or something. Like, it was either 10 or 25 years. It was a very long time. And the judge who sentenced her decided to disregard it, and the 4 years was seen honestly as somewhat lenient.
Yeah, and it was Rakoff, same guy. Judge Rakoff was who she was in front of.
Yeah, and but it's interesting then, I think, to see Newman as the next case, or the next, maybe like one of our next most noteworthy cases decided by the Second Circuit, where they're like, this personal benefit test needs to be more strict. People are getting too loosey-goosey with this. We need to make this more strict. And then the Supreme Court was like, nah, and everything just goes back to Dirks.
Yeah, we end up back at Dirks. And Rakoff is involved with somehow all of these things at various
Yes.
times. But yeah, that's a good point that maybe Chow, to the extent Chow maybe moved this a little bit, we saw a further shift through the Newman, Salman Martoma line of cases, which effectively still brings us all the way back to really looking at taking a hard read and coming back to Dirks, which I think is a great point. Any other thoughts you guys have about this case or insider trading in general?
The personal benefit test drives me crazy.
That's a good takeaway from this class and from our podcast today. It's fair. It's a lot. There's a lot to prove. It's a lot of hoops to jump through, and it sometimes feels very squishy, especially when facing down significant prison time for these activities. I take that point that maybe it does need to be a little more clear.
I mean, there's also the concept of lenity, right? I mean, these people don't necessarily know what's gonna be illegal, right? I mean, it seems like the Second Circuit is kind of making things up as they go along, and kind of generating these things out of thin air. Do I think that there's probably a conspiracy here? Absolutely. But if they're sticking to the standard that they're outlining, I don't think they proved certain elements according to the standards.
Yeah, at least vis-a-vis the transactions. Yeah. No, that's, I think, a fair point. Yeah, I think, and the idea of lenity is a good one, and I think gets brought up often when we are in this space where it does feel like, because all of these insider trading cases come down to just the facts and circumstances of those particular cases that came before, there's not much guidance from the statute at all. So it just keeps evolving with each new case. And so that in itself makes it seem like this is a very dynamic standard that can also result in criminal liability, which is not nothing at all. So I take your point that lenity is, I think, hopefully can be used generously in this area if it's too confusing.
I will say, I guess one final note was I had learned about is it Rajaratnam?
Yeah.
Like through this case. And yeah, I was very unhappy reading about how he was able to post bail because he's a billionaire. And yeah, his bail was $100 million, but that was very feasible for him. And that even though he had dual citizenship and a private jet, that was not enough to prove like flight risk to keep him in jail. Zhao was kept in jail, partially because she was seen as a flight risk, which wasn't, I don't think that was necessarily a wrong call, but also she didn't have enough money, I don't think, to be able to fly, to be able to escape. And yeah, her just being kept in a maximum security prison really did not sit well with me at all.
Yeah, it does seems like some different maybe levels of justice given all of the cast of characters that were involved in the Galleon group sting. That's a good point. But I think you're right that where we are at the 30,000 foot level is back to Dirks to some extent, back to square one, even though Chow might have shifted this somewhat. Same with Obis. We have some minor shifts on what the Dirks standard really looks like, but at the end of the day, we really come back to it's almost like Dirks is the statute at this point. We all just come back to that Supreme Court case as the guidance sort of from here on out. But thank you guys. This was so informative. I've learned a lot about this. I know I don't spend as much time on this case in the class, so it was great to have you guys explain it to me and hopefully to all of the listeners. And I hope you guys tune in next week when we talk about more cases related to insider trading.
Thank you so much.
Thank you.
Okay.